You have 2 degrees, a BA and an LLB from the University of KwaZulu-Natal.
That's correct, Jay.
What were your majors in your first degree?
I beg your pardon?
What were your majors in your first degree?
Political science and English.
Right. You joined the Pietermaritzburg Bar in 2007.
That's correct.
But before that, you had worked for a number of years at the Commission
Restitution of Land
on
Rights.
the Restitution of Land Rights. What did you do there?
I initially joined the commission as an admin officer.
I'm sorry, just speak into your mic. I'm struggling to hear you.
Sorry, I initially joined the commission as an administration officer, where I assisted with negotiation support. And thereafter, I became a project coordinator, where I then researched and helped settle claims. That meant doing the entire investigation, going out to the community, verifying the claimants, the beneficiaries, and then making a submission to the commissioner and the minister to then settle those claims.
I imagine that you appear frequently in the land claims court.
Not as often
Not
as I would love to, but I have appeared in the court.
All right. So what kind of practice do you run?
My practice has now become a more civil-orientated practice. But when I first started practice at the bar in Pietermaritzburg, I was not from Pietermaritzburg, so I was not familiar with most of the law firms. And in terms of the taxi cab rule, I had to take what work was given to me. I did a lot of criminal work in terms of being briefed by the Legal Aid Board for about the first 5 years of my practice, with a few civil matters. And then after, I got more work in terms of personal liability claims for and against the RAF. And then I got to work some liquidation, some matrimonial law matters, some labor court matters, as well as some land claims matters.
Right. When did you start acting in the High Court?
In January 2024.
And when was your last stint?
I just came out of a stint now. I did do recess duty, and I had a stint in the last session.
Okay. And how long have you acted as a judge in all?
In terms of my calculation, in terms of my application, there were 37 weeks at that time. Subsequently, I've done a further session and recess duty. Together with the voluntary acting, you're looking at 43 weeks in total.
And have you had a chance to write any judgments during that time?
Yes, I did. In terms of the 3 judgments that I've submitted, I've written a further 46 judgments, out of which 36 were delivered. In terms of the other 9 judgments, they were ex tempore judgments, which I have delivered immediately after the matter, after considering the facts on the same day. Those are the judgments that I've written.
All right. And you cleared your desk. Do you have any outstanding work in the division?
I beg your pardon, Chief Justice?
Did you leave with your desk clean? Any outstanding reserve judgment, old reserve judgments, that is?
No. So I was hoping to have achieved the same before I had filled in my application. But unfortunately, on Friday, I heard an application for leave to appeal. And although I had a prima facie view of what I was going to do, I had to reserve the judgment because there were other factors that I needed to consider. So based on what happened on Friday, I do have one outstanding judgment which I would prepare.
All right. Judge President Boyot.
Thank you, CJ. Good morning, Advocate Nirghin.
Good morning, JP.
Just on what, follow up from what the CJ has asked you about reserve judgments, what is the longest period that you've taken to hand down a judgment?
I think it was just over the 3-month period. That was as long as I've taken.
Did you explain yourself to myself or the DJP as required by the Judicial Code that when you're going to take longer, you have to explain yourself, or you were not aware?
No, I was not aware, but I think it was 1 or 2 days, so I wasn't sure of that, JP.
Yes. Are you aware with the judicial code?
Yes, I am.
Yes, and the norms and standards?
Yes, I am.
Yes,
I had to familiarize myself with that.
yes. All right. And have you done an acting stint in Devon? I just don't recall if you have.
Yes, I did. It was when Judge Sigubin was called to the Constitutional Court. I was called in and I did an acting stint in Durban.
And between the Maritzburg and the Devon High Court, is there any difference? It's one division, but is there any difference in terms of workload or anything else?
I didn't find a difference. There is a lot of work at both divisions, at both courts. It was just a matter of the traveling, but that was manageable. So I'm quite comfortable in both environments.
And how have you found the judges in the division whilst you were acting?
Very collegial, very helpful. Everyone puts in a lot of work, a lot of effort, and they have an open door policy. The attitude is that we need to deliver justice. And if anyone is stuck, especially acting judges, everyone has the attitude that please come and find out so that we do the right thing. And I found that very encouraging, very supportive, which is good. It assists to calm a person down to ensure that we can deliver justice at the end of the day.
Yes. And in your form, you say you are a member of the KwaZulu-Natal Legislature Interfaith Symposium Planning Committee. So my understanding is that you're not a member of the legislature,
Yes,
but of that committee.
That's correct. This is a public participation committee where the legislature reaches out to the community. And because of my involvement in the faith sector, at that time I was a member of the South African Hindu Mahasabha, which I'm the president of now. I was delegated to be on that committee for interfaith dialogue and to ensure that the faith sector gives its input into the legislature.
Yes. So just on that presidency, you've taken over from the late Mr. Trikamji.
That's correct. Yeah, it was. Sorry, JP. Yes.
Yes.
Yes. It was sad that I had to do this. It was unexpected, but the organization felt that I would be most suited to take over, and then elected me as the president of the South African Hindu Mahasabha. Subsequently, we've had a BGM, and I was re-elected into that position.
So if you get recommended and eventually appointed, will your community not suffer because Mr. Trikamji has just passed away and you've just assumed that responsibility? What is your view on that?
I believe with my leadership style, which is slightly different from that of the late Ashwin Trikamji, we have something like 23 subcommittees that deal with the different responsibilities of the South African Hindu Mahasabha. And I've ensured that all of these subcommittees, the chairpersons, deal with whatever needs to be delegated to them, and all I do is coordinate. So I'm not going to be, as much as I respected the late Ashwin Trikamji, I'm not going to be in the same position that he was in, because I want people to see that there are more than one person in charge of the Mahasabha. And it's not a one-man band. There's an entire team of people that are doing dedicated work for the community on a voluntary basis. So I don't think it will impact if I'm appointed, because I think I've been able to strike a balance. I've been able to balance my community involvement with my practice, and I have a varied involvement in the community because I believe that is a sector that I need to add value to. And when people ask me what I do for fun, that is what I do for fun. I actually enjoy serving the community.
Yes. And the BLA says they do not support you, but I'm not sure of the actual reason. I think they said lack of experience. I'm not sure. What is your comment on that?
I was a bit surprised, but when I look at it, It's simply, we do not support this appointment as the candidate appears not to have acquired enough acting experience in the High Court. We do not support his appointment. So my understanding of the norms were that one should have at least 24 weeks of acting. I have acted for more than 43 weeks. I think I've acquitted myself in a dignified manner. I've been impartial. I've conducted myself with what I would consider judicial temperament. So I respectfully disagree with the BLA. If one looks at the comments made by AFT and the GCB, it's contrary to the comments made by BLA. But each organization is allowed to have their view. Unfortunately, they didn't substantiate why they felt this way. It's a two-liner on their comments.
Yes, and in addition to your acting stints, you appear regularly in the motion courts and also in the trial courts, and you conduct
That's
trials.
correct.
Yes.
So, I mean, I've been in the High Court. I've appeared in both criminal and civil matters, in trials, in opposed motions, and just ordinary motion court briefs. So it's unfortunate that I don't have actual reasons why the BLA went in that direction. But I think the proof is in the number of judgments that I've given, the number of matters I've heard, as well as my conduct. The advocates that appear in court have given a different view of my conduct and my suitability to be appointed as a High Court judge.
Yes. And perhaps the one area I think that you have not had sufficient exposure is the criminal courts, because we've always allocated you civil work. Because in the division, the view is the sitting judges must do the criminal work, because people in the criminal courts give the acting judges a runaround when it comes to the matters proceeding. So for that reason, I think you've had one stint in
Yes, I have.
5 weeks in the criminal courts. So with that is an area there where I want to ask you one or two questions. What is a test for an application in terms of Section 174?
Well, was a prima facie case made out which the accused needs to answer or not? I just came out of a trial now where I refused 3 applications in terms of 174 because I felt a prima facie case was made out which the accused had to meet. They then subsequently closed their case, and I then acquitted the 3 accused because the highest standard of beyond reasonable doubt was not met by the evidence that was presented before the court. So there are 2 different standards that need to apply. And my understanding of 174, it is something that I used frequently during the 5 years that I did a lot of work for the Legal Aid Board. And it's a technical matter. One obviously, as a practitioner, used that to test where the court was going, but the court has obviously seen that from practitioners and has reserved the reasons for being delivered at the end of the judgment. So I think I'm comfortable with applying the principles of prima facie case for a 174 application.
Yes. And in a criminal trial, let's say you have 3 accused. The one accused pleads not guilty, the second one pleads guilty, and the third one pleads not guilty. What will happen in that case?
We'll look at a separation and then deal with the guilty plea separately. And then the other 2 will then go on trial.
Yes. And maybe finally, you are a humble, probably nice person, and I have a reason why I preface it that way. Now, in a full bench, when you go into court, and if the judge, the senior judge presiding, gives an extempore judgment, and then it comes to the last part where they say, I propose the following order and you don't agree, what would you do?
Well, because what normally happens is that both the judges will consider the appeal and discuss the appeal before we go into court. And we'll have an idea of where we are going. I did have a scenario where a senior judge, a very senior judge, had a different view from the one that I had and was quite adamant about his view. I was able to sit with him and take him through the law as I understood it and the case law regarding the issue that he had raised. And eventually he told me, well, okay, you do the extempore judgment. So I think I've been able to deal with that in an amicable manner, also in a respectful manner, respecting senior judges, but also to stand my ground when I differed from a senior judge, especially in light of me being an acting judge. And in that particular matter, the senior judge then conceded that I was on the right track and asked me to do the extemp judgment, which I subsequently did. If a scenario had to arise where we did not agree and the judge goes ahead and gives an extemp judgment, which I don't agree with, I will stand my ground. And I think that's something that we must pride ourselves here in South Africa, that judges are independent. We are not subservient to anyone but the Constitution. And we must put our views substantiated with law on the table in our judgments, so that even if it's a dissenting judgment, we must do so without any fear or favor.
So what would you do? Like the court is sitting and he or she has gone through the facts and the reasons, and will you tell him or her, or will you get the court to adjourn? What will you do?
We'll have to adjourn because there are two different views, especially where there's two judges sitting, and get a third judge to look at the facts as well, and then bring in the third judge to give the deciding outcome of the appeal.
Thank you. Thank you, Chief Justice.
Thank you, JP. Premier?
Well, thank you, Chief Justice. Good day, Mr. Nirghin.
Thank you.
How are you?
I'm good, Premier. How are you?
No, I'm okay. I just have one question for you with regard to the role of the court in educating communities to understand how courts work and their role to make the courts work easy. Is there any role of the courts which is as such?
Not directly, but you have a scenario even in the High Court where you have lay people who come in unrepresented, and then you exercise your discretion in giving them advice on procedure, but not giving them legal advice. I have not seen any program where the judiciary goes out and educates people on what needs to happen in terms of the law and legal processes that need to be followed. So I'm not familiar with that.
Thank you.
JP Tlanidze?
Thank you. Are you a member of a political party?
Yes, I am.
Are you an office bearer?
No, I'm not.
What do you intend doing, because you don't have judiciary of national unity?
Yes. I will reluctantly have to, if I'm appointed, I will have to resign in terms of the code of conduct for judges. It is something that I'll have to do.
Is it something that, I just missed your last word, you say it is something that you have to?
I have to do.
I see. Do you think there needs to be a cleansing period where you stay outside so that that period can go, then you can participate in the judiciary? Is there any need for that?
JP, I think I've demonstrated in my judgments that I'm impartial. I've had scenarios where municipalities that are run by the ANC have been taken to task and I have found against them. I have a scenario, for example, with the Msunduzi municipality where I found for them and against them. So I've exercised myself as a judicial officer, as an officer of the court, showing total impartiality.
So no need for a cooling off period. Thank
For
you.
me personally, I don't think so.
Yeah, thank you.
Professor Marumachai?
Thank you very much, CJ. Good afternoon. Yeah, on this
Good
side.
afternoon.
I had an occasion to read one of your judgments that appear on page 29 of your paginated to page 29 of your questionnaire. I mean of your bundle of documents. It is Tokosise Nyembe Zikubu versus Absa Bank.
Yes.
Remember that case?
Yes, I do.
And that is the case that dealt with the rescission of judgment.
That's correct.
When I read that judgment, I think the applicant relied on Uniform Rule 42. And what appears from your judgment also, it seems like they also relied on the common law rescission. Usually, those two things are relied on in the alternative. In other words, you start first by the uniform rule. If that doesn't work, then you can revert to the common law. But I'm particularly concerned about what is stated in paragraph 37 of that judgment. Because in paragraph 36, you seem to provide a sense of what Rule 42 says, then you provide a sense of the common law. What is not clear to me is, in what you state there, are you saying that is a test for the common law rescission? Because in that paragraph, it seems to me that you are talking about the setting aside of the judgment, and as I understand it, the judgment is about rescission. So I was not quite clear as to what is the actual test for rescission under the common law. Perhaps my direct question to you is, forget about section 42 for a minute. Let's just focus on the common law. What is the test of common law rescission? What is it that the party must prove in order to succeed in as far as the common law of rescission is concerned?
So,
I beg your pardon, it is in paragraph 21. Paragraph 21 of the judgment.
sorry, please say that again.
I was saying paragraph 21 of the judgment.
So, if one looks at paragraph 21, here I deal with the grounds of fraud, specifically because that is the common law ground that the applicant, who was a lay applicant, unrepresented, used. So I only dealt with what was required for rescission in terms of the common law on fraud. That is how this judgment was dealt with. So what has happened here is that you had a litigant who tried to do different things. Although he brought a rescission application, in actual fact, he was bringing an appeal against the judgment. And what we were dealing with was res judicata. So that is why this judgment and the law that I dealt with specifically was common law grounds, which specifically dealt with fraud.
Okay, I'm confused. Was this an appeal to the full court? The full bench?
No, it was not an appeal, and that is why I'm saying when one reads my judgment, you will see that in actual fact, the applicant here tried to bring an appeal against the judgment but couched it in the form of a rescission application. So even his arguments were more of an appeal, saying that the judge had made a mistake, rather than focusing on these in terms of what was the requirements in terms of fraud on the common law, and in terms of the grounds for rescission in terms of Rule 42, 1A and 1B.
Okay. I get that part, but
Okay.
the point is it was not an appeal.
Yes,
So
it's
what I
not.
want to get from you is what is the test for common law rescission?
Okay. So was there an error that was made by the court?
Is that the test?
That's my understanding of the test in terms of common law.
All right,
But
no,
as
I
I
will-
said, there are
I will-
different
I will-
aspects of common
I
law.
will leave it there, but I think you should check on that aspect because it's really important for decisions.
Thank you.
Thank you, CJ.
Thank you, CJ, and good day, Advocate Nirghin.
Good day, Commissioner.
Okay. I see you have a lot of experience in land claims matters, and surely mediation is part of the thing that you do a lot when you were there. Mine is just a comment. I just want to find from you, you have done a lot of land claims matters and also litigation, taking into consideration that litigation is very confrontational. And now that there's a move that we do mediation before matters go to court, in your view, how do you see the two? I mean, because mediation is voluntary. In civil matters, what is your view in doing that mediation? Is it likely to delay the trials, the matters for claimants, or what is your view?
Personally, I would like to see matters going through mediation for several reasons. One being that the roles are quite clogged. It might actually help the parties to arrive at a decision much earlier. The concern with mediation, though, is that it is generally expensive because the parties will then have to foot the bill for the mediator. But I think that mediation should be tried as an attempt to resolve the conflict before the litigants get before a court. It might be expeditious, it might not yield the results that are required, but I do believe that mediation should be tried as an option.
Thank you, CJ.
DP's want?
Thank you, Chief Justice. Good afternoon, Mr. Nirghin. I'm here. Yeah. I've got two questions for you. The one, as at the 11th of June, when you signed the questionnaire, you didn't have any reported judgment. I just want to find out why, and then it seemed that you had acted for 37 weeks. And in that 37 weeks, you couldn't find a judgment that you could mark reportable.
Yes.
Okay. Is it because of the nature of the cases that were allocated to you, or is it?
That's correct. In terms of the cases that were allocated to me, quite a few of them were personal injury matters in terms of the RAF. Those were resolved quite expeditiously. Yes. But in terms of the matters that I dealt with, I relied on precedents. They were not cutting edge where I interpreted any of the matters differently. Even the matter that I put in here as my third case, I didn't think it was worthy of being marked reportable. So I don't know if I'm being too critical of myself, but I think if there's something where I am influencing the way the law needs to be interpreted or interpreted differently, then I would mark it reportable. But I'm of the view that the matters that I've dealt with and the manner in which I've dealt with them have not changed the law in any way.
Okay, fair enough. Then my question to you relates to your experience as project coordinator or administrative officer in the Commission on the restitution of the land rights. There's been a development which is somehow, to me, I think that which has caused me a great deal of anxiety and concern, and it is the following. Now, the majority of claims have been kicked out on the basis that the claims were submitted as a community claim and the community failed to prove that it was a community claim. And my concern arises from the fact that the community that would want to lodge a claim, that will come to the office, would be assisted by the officials of the commission in completing the claim forms. And but somewhere along the line, when they want to change the claim from being one of a community claim to individual claim, that has been prevented. I'm not sure what has been your experience in the Lane Claims Commission with regard to the characterization of the claim as a community claim and changing of a claim from being a community claim.
So, based on my experience, which was obviously before I came to the bar, and we're looking at 1999 to around 2005, when I got to the commission, we had that first cut-off date in terms of the Restitution of Land Rights Act for the lodgement of claims. And many claims on that last weekend before we closed, the Land Claims Commission was flooded with claims which were accepted, which were received and thereafter processed. When I say accepted, in other words, the forms were accepted and thereafter a process was followed in terms of trying to establish what type of claims they were. So it was an attempt to assist the community to, claimants to get the claims in. What we found, KZN specifically, I can't speak about the other provinces, is that sometimes an Nkosi or a traditional leader or someone who purports to be a leader of a community would put in a claim, but not give you the background justifying how it is a community. Or sometimes an individual put in a claim saying that they lived in a particular area, and you would find that in actual fact, that person was a part of a community, and the intention was for it to be a community claim. And that can only be established after an investigation is done. So once a claim is handed over to a project officer or a project coordinator, they then had to go in and then do that research to establish what was actually being claimed. Because sometimes people knew areas by the traditional names, not by what the geographical names or the accepted registered property names are. And you had to then go back and establish what was the extent of that claim, for example. And did it incorporate other community claims? Because sometimes you had different people acting independently, lodging a claim because their families lived in a particular area, either part of a community or sometimes in isolation. And you'd find that there were overlaps. So that is why there is this ambiguity between community claims and individual claims, specifically in the rural area.
Okay, thank you. Yeah, it's something that I think that needs to be addressed because I think that it's unfair to the claimants. But
I agree with you. I also have a personal grievance with the way the Restitution Act has been drafted. Because in a situation where urban claimants have put in a claim for a registered property, the claimant is still defined as the person who lodged the claim. So if you have siblings who ought to have benefited from that estate, they excluded. They only realized that the sibling who put in the claim was only acting on their individual capacity and not on behalf of the entire family. So there is room for maybe an amendment to the Restitution Act to actually deal with these issues that we are grappling with here today.
Okay, thank you.
Commissioner Hassan?
Sorry, Chief Justice, got excited because it's land, but
Well, she raised her hand for a follow-up before you. Or it's not? Okay, go right ahead, Commissioner.
Yes, all right. Thank you, Chief Justice. You see, Advocate, sorry, just give me your name again. Nirghin. Yes, Nirghin, yes. Thank you. This issue around the community claims has its source in the Restitution Act itself, in the definition of community, which the courts have grappled with since the judgment of Judge Moseneke, I think it was Grootgelegen. And what has happened is that the community has become narrower and narrower through jurisprudential devices, right? And that is why these days you hardly find a claim qualifying as a community claim. And the last of these cases was that case of Mhlanganisweni. Now, landowners like this. They like causing the division by objecting to the character of the claim as a community, which questions the people behind the claim and says, you are not a community. Which for me is ahistorical because it ignores the impact of settler occupation on communal identity. Whereas land claims are meant to resolve settler occupation. And the problem with settler occupation was that it disrupted the communal character of tribal societies. So now you are asking people in 2025 to reconstitute themselves as they were in 1913, when the very point of 1913 was to cause internal instability. Now, when you say you are proposing an amendment, what is the amendment that you have in mind that will solve the problem of the settler instability to communities?
We are going on I think an area that we both appreciate. I think you have done more research than I have, and it's an area that I've worked in. 1913 is most definitely a stumbling block in terms of the Restitution Act, especially since you've got title deeds that go back into the early 1800s. And my view is that we need to re-look at the 1913 Native Land Act as being the marker for the start of classification of community claims, because many of the communities get bowled out using that date in particular, because then the landowners simply say that, well, we have a title deed that pre-existed the 1913 or your requirement. So it's the community existed well before. I agree with you. I myself have not formulated what the change should be, but this is something that we have to come to terms with. Otherwise, we're going to constantly be revisiting communities that are going to be excluded because of the narrow interpretation of the Act and the way it is structured. And I think the amendment that was passed and then suspended went a little way further, but it didn't address the 1913 elephant in the room, and that needs to be set aside. That's my view.
Yes. And you see, again, I mean, you know, the problem with 1913 is that they succeeded, the landowners, to constitutionalize it. So it's in Section 25 itself. So if we want to remove, and I agree with you that 1913 is in fact the primary problem with land reform, that will mean we must remove it from Section 25 itself. Do you agree with that?
Yeah, that's going to be a challenge. We're going to have to do a lot more work and get a lot more consensus as a nation. But I think it has to be done. Effort has to be put in there.
Sorry, Chief Justice. Then the last part, you know, assuming that we cannot remove.
I suspect this is a conversation you should have with
All right, thank you.
Mr.
I'm
Nirghin
not pursuing.
offline, not here.
I think that the passion for land rights, and specifically our community, is important. But I agree with you, Chief Justice, that this is a conversation we should have about innovative ways to resolve a major issue in our nation.
Indeed. Commissioner Hassan?
Thank you very much, CJ. Maybe just before I start, it is wonderful to see candidates interview at the JSC who are so passionate about land and transformative restitution. So it is, I agree, a question for later, but it is interesting and wonderful to see that that kind of thinking is happening even beyond just some of those discussions that are happening in the media. Advocate, my question is a little bit different. You spent decades building cases from the bar. And so I'm interested in, you can decide in 2 minutes or however long, tell us 3 advocacy habits that you'll carry with you should you be appointed to the bench that will improve justice in such a high volume court.
I think I'll focus on one. It's very important when we get to be, when you get a brief, you isolate what the legal issue is that needs to be focused on for your client in the matter. When I get the cases allocated to me, whether it's motion court or a trial, I look at what the areas are. I formulate a prima facie view of how to expeditiously deal with the matter. Generally, when counsel comes to see me, I would give them my prima facie view, and that has more times than not resulted in a consent order being granted. Now, the expertise or my personal character trait that I would bring in is to focus on specifically what needs to be resolved, cut out all the what I would consider peripheral issues, and deal specifically with the matter at hand. I think I have that ability. I've demonstrated that. Sometimes the attorneys have reluctantly not given me work because I don't flower what needs to be given and drag out matters. But that's just the nature of who I am, and that is something that I will bring to the bench if I'm appointed. Also, in terms of dealing with people who are indigent or less fortunate or may not be able to afford the fancy law firms or attorneys or counsel to defend them, I've also had a passion to try and do as much as I can at a minimal cost. In terms of what happens in court, you would see up to now, we still have a scenario where certain people would pitch up, counsel, senior counsel, junior, a whole lot of attorneys and bundles of documents even for their opponents, where the opponent is just a single litigant on the other side, maybe an advocate or an attorney, and sometimes maybe not as well prepared as he or she should be because of the lack of resources. So I think I display a matter of compassion without obviously prolonging a matter, but trying to ensure that the litigant's case is put before the court in the most effective manner without discounting the fact that there is a lack of resources. So that is something else that I'll bring to the judiciary if I'm appointed.
And then last follow-up, is there an example that you could maybe cite from your acting stints in which you applied exactly what you've just unpacked for us?
If one looks at the matter that we were referred to earlier, the Sukubu matter, there Mr. Sukubu, unfortunately, he has tried various manners in which to try and get his property to remain his in the way he's challenged Absa Bank. And sometimes very rude. Sometimes I know that he has reported different judges that have dealt with the matter previously. And I was able to calm him down and allow him to present his case, much to the frustration of the representatives of Absa Bank. And although I found against him, I haven't seen or heard of a report against me and the way I conducted the matter. I do know that he has taken the matter to the Supreme Court of Appeal for leave to appeal, and that was turned down. and I do know that he has now tried to bring an application for leave to appeal to the Constitutional Court. But I think what's important there is that the manner in which I've dealt with him was to allow him the freedom to put his case before the court. I indulged him without prejudicing his rights, although I found against him.
Thank you, CJ. I'm comfortable.
We've reached the end of your interview.
Sorry, CJ.
Oh, yes, JP?
Yes, thank you. May I just follow up on just one issue? On the question asked by Commissioner Moremohai on the rescission of judgment, and I want to refer you to paragraph 23 of that judgment. Yes, so you say there, it is clear that the applicant was present in court for the hearing of his matter on the 31st January 2022. He participated in the trial and made submissions to the court. There is no evidence that this matter was heard in his absence. Are you there?
Yes, I am.
Yes. So if that litigant was not present when the matter was heard, what would that litigant have to prove for the granting of a rescission?
Well, in that specific scenario, if the judgment was granted erroneously in his absence, then he just has to prove that he was not present in court on that day. In this case, it was clear that he was present in court.
Anything else that he has to prove?
Sorry, JP. I think, I don't know whether I've got brain fog.
I think you have.
I think he also has to go to the extent of showing that the judgment was actually erroneous, not just that he was absent. So it's not just left on the basis as he was not present, so he automatically has a right to have the judgment rescinded. But he also has to show that there are prospects that he would succeed. But we didn't go that far in this matter.
And in the prospects of succeeding, what would they have to prove?
That he has a reasonable case, and obviously that evidence has to be presented.
A bona fide defense.
But definitely a bona fide defense.
Yes. Okay.
Sometimes the obvious escapes us when you're sitting here.
Thank you. Thank you, Chief Justice.
Thank you.
Thank you, JP. Minister?
Thank you very much, CJ. Just one question from my side. Good afternoon, Advocate
Nirghin.
How are you?
I'm good. How are you?
I'm okay. I have been asking this question of access to justice for our communities, especially those that are coming from the vulnerable communities. Are you able to share with us what mechanisms that the judiciary can put in place to ensure access to justice for the most vulnerable, especially in a rural province like KwaZulu-Natal, where majority of the people will have to travel long distances to access justice?
Well, I think we're fortunate when it comes to litigation. We've got the magistrates' courts, which are generally based in the community. With regard to the High Court, there may be a need to decentralize. I know there's talk about Richards Bay being an option of decentralizing, maybe having a seat in Richards Bay, but I think access to justice at the different levels, but it all comes down to what is the ideal would be for everyone to be able to access the courts and have courts in as many localities as possible. But I think the first entry is at the magistrates' court. In communities, you will have traditional courts. But when it comes to the High Court in particular, maybe in a big province like KwaZulu-Natal, we need to look at further subdivision or further locations where the courts can be held. At the moment, we do have circuits that go out to areas where communities are based so that the matter can be dealt with on the circuit or in the locality or as close to the community as possible. The other thing is for access to justice. I think we've gone a long way as a country in terms of the establishment of the Legal Aid Board. But I think there we need to also look at roadshows or things that need to be done in the media to remind people that they can access the Legal Aid Board to represent them in litigation matters, whether it's criminal or civil. Maybe also we need to lower the bar in terms of entry requirements for them as well.
Thank you, CJ.
Thank you, Minister. We have reached the end of your interview now, Advocate. You said
Nirghin.
Nirghin.
We need to roll the R.
Yeah. Do forgive my unruly
No
tongue.
problem.
All right. Thank you for making the time to present yourself here.
Thank you. Thank you for giving me this opportunity, and I hope I can serve our nation.
You're excused.